All right, let's just jump right into this explainer. Today, we're looking at a high-stakes construction dispute where, honestly, the biggest nightmare isn't even the project itself. It's not a supply chain delay, it's not a crazy material shortage, it is literally a poorly drafted arbitration clause. So we're going to break down the anatomy of a truly bulletproof agreement. The goal here is to make sure your disputes actually get resolved, rather than just stalled out in these endless, ridiculously expensive preliminary court battles. To really wrap our heads around this, imagine this comic case scenario. You've got project director Arjun on one side and client representative Ms. Kapoor on the other. They are locked in a massive disagreement over a huge construction project. I mean, millions of dollars are on the line here. But the absolute tragedy, their drafted agreement is so incredibly vague that they can't even agree on the basic rules for resolving their disagreement. It's a total mess before it even starts. And that brings us to the million-dollar question. How exactly do you resolve a dispute about how to resolve a dispute? It sounds like a joke, right? But frankly, it's the exact issue that brings major, complex projects to a complete, grinding halt. When your arbitration agreement is ambiguous or just poorly put together, you end up creating this disastrous second dispute just to figure out the first one. So instead of arguing about the actual construction delay, Arjun and Ms. Kapoor are paying top-dollar lawyers just to argue in court about whether they're even allowed to go to arbitration in the first place.
Okay, let's move right into Act 1, the disputed dispute pathway.
Think of your contract clause as a pathway. An effective arbitration process is built entirely on three solid pillars. You need clear consent to arbitrate, a clear procedure to actually follow, and a clear forum to host it. The foundational texts on arbitration are super strict about this. If literally any one of these steps is ambiguous, the whole pathway completely collapses. And what that does is it basically hands an open invitation to any party who wants to derail the process, letting them drag you into court to challenge the entire jurisdiction. Moving right along to Act 2, scope, rules, and seat. So your very first essential element is the scope of disputes. You really want to use broad, inclusive language here. Something like arising out of or in connection with the contract. Why? Well, because rational business people generally intend for all disputes related to a contract to be handled by the exact same tribunal. Using this specific, broad wording acts like a giant net. It ensures virtually all disagreements go straight to arbitration, which completely sidesteps those messy, nitpicky jurisdictional battles over whether a specific little claim was technically covered by the clause. Next up, element number 2. You gotta choose your arbitration rules. For example, commercial manager Ravi needs to know exactly which procedural playbook he's supposed to follow the minute a claim is filed. You generally have two routes. Institutional rules, like those from the KLRCA or the ICC, give you this safe, heavily tested, preset framework. Ad hoc, on the other hand, leaves you to build the rules completely from scratch, which, hey, is totally fine, as long as you actually remember to specify what those rules are. The third crucial element is the seat. And real quick, do not confuse this with a physical chair. The seat actually anchors your arbitration to a specific legal home. This is an absolutely critical choice because it dictates which nation's courts have the ultimate power to supervise the arbitration, or, even worse, set aside your final award. Basically, your seat acts as your underlying legal safety net. All right, on to Act 3, venue, language, arbitrators, and law. Let's see how these pieces fit together. This brings us to a classic everyday mix-up, which is essential element 4. It is so vital to remember that your legal seat could be, say, London, which means English courts are legally supervising the whole process. But your hearing venue, that could just be a convenient conference room somewhere in Kuala Lumpur, right? The seat is this invisible legal concept, whereas the venue is literally just the physical room where you drink coffee, lay out your documents, and actually argue your case. Elements 5 and 6 are pure practical lifesavers. First, you have to explicitly state the language of the arbitration. I mean, imagine the absolute nightmare of later disagreeing over translating 10,000 pages of complex construction documents. No thank you. Second, clearly define how your arbitral tribunal will be appointed. Are we talking about one person or a panel of 3? And crucially, who appoints them if the parties just can't agree? Specifying a default appointing authority upfront saves you months, literally months, of painful deadlock. Finally, for element 7 regarding the governing law, you've got to separate 3 entirely distinct legal layers, because this is where things get super tangled. Think about it like a cake. The contract itself might be governed by Malaysian law, right? But the arbitration seat might be governed by Singaporean law. And then the procedural rules might be ICC rules. Defining these three layers clearly, right out of the gate, completely avoids total confusion between the contract's substantive laws and the arbitration seat's procedural laws. Let's transition into Act 4, 4 fatal drafting pitfalls. So, knowing all that, where exactly did Arjun and Mrs. Kapoor's contract go so wrong? Well, pitfall 1 is naming a specific individual. You might sit there and think, oh, Mr. John Smith is a fantastic engineer. Let's just write him right into the contract as our arbitrator. But hold on. What if 5 years later, when the dispute actually blows up, Mr. Smith is completely unavailable, or he refuses to act, or heaven forbid he's passed away? Your entire arbitration agreement might suddenly become unworkable. The sources strongly recommend naming an appointing institution or a specific process, rather than tying your fate to one specific human being. Pitfall 2 is establishing impossible, pie-in-the-sky deadlines, like setting a rigid rule that a final award must be issued in 10 days for a complex, multi-million-dollar construction dispute. I mean, there is just no way. That practically guarantees procedural unfairness. The tribunal will be forced to rush and cut corners, and a rushed award is incredibly vulnerable to being thrown out by the courts, because the losing party will absolutely argue they weren't given a reasonable, fair opportunity to present their case. Now, beware the power of a single, tiny word. Pitfall 3 is vague wording. Using weak, permissive words like may refer or parties can consider instead of strong mandatory terms like shall is basically begging for an immediate jurisdictional objection. A judge looking at this might interpret may refer as just an agreement to agree later. And guess what? Agreements to agree are completely unenforceable. So pro tip, always use shall. Pitfall 4 involves those super complicated multi-tier dispute clauses. This is usually where drafters try to be a little too clever for their own good. Having all these cascading steps, like first mediation, then adjudication, then expert determination, and finally arbitration, without clear sequence triggers or strict deadlines, that creates an escalating disaster. If it's not clear exactly when one stage formally ends and the next one begins, a party can easily stall by arguing that you haven't technically fulfilled the preconditions for arbitration, effectively stopping the whole resolution process cold. Which brings us to our final act, Act 5, the Bulletproof Clause Checklist. Thankfully, our arbitration counsel, Dr. Rao, is here to clean up the mess and establish a rock-solid, bulletproof agreement using a very strict checklist. This list right here contains absolutely everything you need to ensure your dispute actually makes it to Justice Sen's arbitral tribunal without getting completely derailed by silly technicalities. From ensuring a broad scope and clear rules to setting realistic timelines and defining a concrete legal seat, checking off every single one of these boxes actively protects the integrity of your entire dispute resolution process. As our comment case comes to a close today, I really want you to remember this vital underlying truth from the material. Drafting precision does not guarantee you are going to win the fight. I mean, if your construction work was genuinely terrible, you are still going to lose the case. But, and this is a big but, a bulletproof clause is the absolute prerequisite for having a fair, efficient, and private fight in the first place, rather than wasting years of your life and your client's money arguing in court about jurisdiction. Keep this educational disclaimer in mind for your own projects, of course, but I want to leave you with a final, provocative question to ask yourself today. Go back and look at the very last contract you signed. Is that dispute clause creating a clear, smooth pathway to resolution? Or has it secretly laid the groundwork for a massive, expensive second dispute? Go check those clauses, and I'll catch you in the next explainer.